Good morning and welcome. I'm Melanie Ramey, and I'm very pleased to welcome you to this special breakout room on legal strategies to combat voter suppression laws. We are really very fortunate to have with us John Sherman. John Sherman is an attorney, and he is the chief litigator and director of the Fair Election Center. John has had extensive experience in litigating laws in Wisconsin that have attempted to suppress the access to the ballot box. John has also litigated many cases in the various states across the country: Louisiana, Tennessee, Georgia, Kentucky, and even others. He has been particularly interested in the laws in Wisconsin because we have been sort of a testing ground for laws that have attempted to restrict access to voting and also to undermine our democracy. I would also call your attention to the fact that we are going to be handling questions at the end of John's presentation, and you can ask your questions by clicking on the chat room. The chat is at the bottom of your screen. For some of you have the word chat, others of you have the word more, and you click that on, and in that list is chat. And so you can click on the chat to put your questions there. I will also ask the questions to John, as many as we have time for. I would also point out that we are in a particularly difficult time with regard to voter suppression laws. Back when we started, and the League was the first group in the court in 2011, when the voter ID law came into effect. Since then, things, I must say, have not improved, but have gotten worse. And what we're seeing now is really an attack from several directions. One of the directions, of course, is continued legislation being introduced, as this year there was more legislation attempting to regulate more strictly absentee voting. Now then, what we're seeing is an attack upon the clerks throughout the state. And this, of course, is a very insidious kind of thing, because if people do not have confidence in the way their local elections are being administered, then this undermines their whole belief in the system of fairness and democracy. The final thing came just this week in a demand for the resignation of the director of the Elections Commission. Now, this has happened before. Her predecessor was an excellent person, did an outstanding job, but was forced to resign. Now then, she is coming under attack in the same kind of way. So it's a very difficult time, and it is not a time we can be complacent about. We have led the fight in this state against voter suppression laws. We are in every case practically that's coming into court, and I think we will continue to be. And so I think John will be very helpful in helping us to understand exactly what kind of strategies that we need going forward. And we're really happy that he could be with us this morning. So without further ado, I will turn the breakout session over to John Sherman.
Thanks, but I think Mel Barnes needs to be introduced as well. We're both presenting, I think, during this breakout session. Is someone going to introduce Mel, or should Mel introduce herself?
I can do that quickly.
Yeah.
Hey, everybody. I'm Mel Barnes. I'm staff counsel at Law Forward. We're a nonprofit litigation firm focused on advancing democracy in Wisconsin. And we have the honor of working with really smart lawyers around the country, including John, to work on not just voter suppression and these types of litigation in Wisconsin, but also redistricting and other issues that really impact our democracy. So John's going to kick us off by talking about some national issues, and then I will turn more specifically to Wisconsin, although we've worked together so we can really tag team on answering questions, and hopefully our talks will play off of each other.
Great. And thanks, Melanie, for the introduction, and it's thanks for having me today. It's great to be with all of you. Wisconsin is figuratively or professionally home for me. Next month marks 10 years from when I, in a different capacity, filed my first case as a voting rights lawyer, the first federal challenge to Wisconsin's voter ID law. I remember driving up from Georgia where I was working. I drive from Georgia up to Milwaukee and Green Bay and Madison and other cities, and recruited plaintiffs for that case in homeless shelters, at college campuses, senior citizen centers all around the state. And that case is still pending, I believe, a decade later after 3 trips to the Seventh Circuit. So the fight is sort of never over in Wisconsin. So there's a lot of voting rights litigation. There's a lot of things we could talk about, and particularly if we could, Mel could fill 5 hours just talking about Wisconsin voting rights litigation. I'm going to try to in 15 minutes, and I forgot to start my thing here. Hang on one sec. I wanted to just time myself. So, in a national landscape, we could be here for days. What I'm going to focus on is just going on offense, right? I mean, there's a lot of voting rights litigation where people play defense. If you go over to Mark Elias's website, the Democracy Docket, where they track all of their litigation, but you can filter for the victories they've had. 9 or so of the 13 pages of victories they have are defensive litigation, where they were on defense in last year's presidential election, and most of those cases came after the election. So there is a great deal that I would qualify as voting rights litigation, where pro-voter parties are intervening as defendants to defend against some anti-voter attack that's being brought by plaintiffs hostile to democracy and hostile to voting rights. So focusing on offense, and I'll focus first, on federal court and the different strategies that Fair Election Center and many others in the voting rights community have pursued in federal court. And just to get one thing out of the way at the outset, I'm sure if you've followed the news at all on this, you've seen that the Voting Rights Act has suffered some pretty severe setbacks over the last 8 years, starting with Shelby County, but more recently with a decision in the case called Brnovich, which severely restricted the use of the Voting Rights Act to combat racial discrimination, really discriminatory effects in voting. We don't need to get into all the details of that. Suffice it to say that decision all but sounds the death knell for using Section 2 of the Voting Rights Act to really combat voter suppression measures. But to be realistic about this, and just to say, put some perspective on that, the statute wasn't being used all that much. It wasn't being used all that much outside of the redistricting context to begin with. There's one win I can point to. The Texas voter ID law was struck down on Section 2 grounds. Even the Obama administration, the Obama Department of Justice, only brought 2 cases under Section 2 of the Voting Rights Act. When various voter suppression measures were struck down on racially discriminatory grounds, they were struck down as intentional discrimination, and you don't need the Voting Rights Act to strike something down as intentional discrimination. So those cases out of North Carolina and Wisconsin that found intentional racial discrimination within the last decade, you don't need the VRA for that either. So while it's terrible that it's been eviscerated by the court, Section 2 of the Voting Rights Act wasn't being used all that much. It wasn't doing much work. It might have had some deterrent effect, but largely the deterrent effect of the Voting Rights Act, I think, has been waning since Shelby County was decided 8 years ago, gutting the preclearance provision where all certain covered jurisdictions had to submit all voting changes to the Department of Justice or secure a declaratory judgment approving that voting change. So that happened 8 years ago. And ever since then, it's sort of been like a Pandora's box, as been opened and unleashed a further wave these last 8 years of voter suppression measures. So moving on from the Voting Rights Act, what else is there? And I always think, there's always another legal strategy. There's always another case. There's always something else that has not been tried out. And I'm very agnostic on like what kind of claim and what kind of theory we use to win. A lot of cases are brought under the US Constitution, and one of the bread and butter sort of claims is this X law imposes an undue burden on the right to vote. A lot of cases that have been successful in recent years have been cases challenging signature verification. The results of these cases have, judgments have been attained that require notice and an opportunity to cure any signature defects, a missing signature, a perceived mismatch in a signature. There's been success on that in Georgia, Florida. In Michigan, there was a settlement to update guidance around signature verification, and there's ongoing litigation around this in Arizona. And the ACLU and the Democratic Party's lawyers over at Perkins Coie, now Elias Law Group, have sort of pioneered those cases, and they've been very successful. Last year, there was a whole wave of undue burden cases filed under the US Constitution, including brought by my organization, and including in one case brought on behalf of the League of Women Voters of Wisconsin. Our case, unfortunately, wasn't successful, but there were cases that challenged witness requirements, the imposition and enforcement of witness requirements during the pandemic. Those resulted in wins in Minnesota, Virginia, and Rhode Island. In all of those cases, the states settled and agreed not to enforce witness requirements during the pandemic election. There was also litigation over who qualifies to vote absentee. Certain states had severe restrictions still have restrictions on who can vote absentee. And there was some mixed success on this. We had some success in Kentucky with our state court litigation, and there were others who were in federal court in expanding, at least for the duration of the pandemic, expanding who could vote by absentee ballot. Louisiana, mixed success. Nevada had some success as well. There have also been, like I said, there's any number of directions we could go here. Witness certification errors. We drafted a letter on the League of Women Voters of Wisconsin's behalf some 5-6 years ago now, and the mere threat of litigation over that compelled the Wisconsin Elections Commission to back down and reinterpret the statute so as to provide for not to reject ballots simply based on minor defects or minor omissions, such as a zip code in the witness certification. So that was an important win that we didn't even have to actually file the complaint we drafted. There's been success on these grounds in challenging ballot collection restrictions. The proof of citizenship case in Kansas, they struck down the proof of citizenship law in Kansas. That was an ACLU case. That was also an undue burden on the right to vote. So these are all just examples of success that's been had with the sort of bread and butter, litigate constitutional theory. This law imposes an undue burden on the right to vote. But that's only one of many potential ways to attack voter suppression measures. The due process clause. The due process clause has proven successful in a number of cases, including over the last year or two. In North Carolina, we represented the League affiliate and Democracy North Carolina, along with the Southern Coalition for Social Justice, and using the due process clause, which requires notice and an opportunity to be heard before you're deprived of, say, your status to register, or say before your absentee ballot is rejected. Excuse me, we won a judgment that allowed for voters to cure their absentee ballot, to cure any minor defects in an absentee ballot. And that litigation is still pending. We had a preliminary injunction, and now we amended the complaint, and they moved to dismiss our complaint, so we're still pending in that case. In Wisconsin, we filed again on behalf of the league. We filed a due process case over the Eric voter purge. And though that was dismissed as premature, it did put a lot of pressure on the commission, and I do believe was a big reason that the Eric voter purge didn't go through. I know Mel will be talking more about that. Also, the First Amendment. The First Amendment, we forget that the height of political expression is voting, and all political expression is protected by the First Amendment. But it's only recently that I think folks have really started to file cases under the First Amendment, explicitly citing the First Amendment doctrines and cases, and saying, you know what, these voting rules violate this First Amendment doctrine. This is something near and dear to my heart. We brought a case in Florida some time ago, and now have a case that's pending in Kentucky, challenging the arbitrariness of restoring voting rights to people with felony convictions. We initially were successful. We got a judgment in Florida that said you cannot give government officials arbitrary power to determine who can regain their right to vote. And that's a long-standing Supreme Court precedent. It goes back over 80 years. For over 80 years, the Supreme Court has said you cannot give government officials arbitrary power over who can exercise their First Amendment rights. Voting is a First Amendment right. Therefore, arbitrary reenfranchisement is unconstitutional. That case was mooted in Florida when the constitutional amendment was passed, restoring voting rights to all felons who had served out their sentences. In Kentucky, we are still pending. We were initially found to be moot. Our case was not moot. We took it to the Sixth Circuit and recently just won that appeal. And now we're back in district court where we were 2 years ago. So the pace of justice can be really, really slow. A couple other items, basically, this is a tour of places we've had, we in the voting rights community have had success. There are lawsuits challenging restrictions on third-party voter registration drive activity. We had some success on this in a case we were involved in Tennessee. We have a pending case right now in Florida where we're challenging on First Amendment grounds, due process grounds, some of the restrictions that have been posed on groups that are just trying to register folks to vote. The voting rights community, I would say, lost a real champion of voting rights when Project Vote closed, and ACLU and others and Demos have taken up some of the reins here in bringing cases under the National Voter Registration Act. In Wisconsin, because you're exempt from the NVRA, you may not focus much on the motor voter law, but the motor voter law, of course, around the country has been just an amazing tool for increasing voter engagement, and litigation to enforce the NVRA has resulted in hundreds of thousands, really millions of people around the country being registered to vote. And that's not just at DMVs, it also requires under Section 7 that people be registered at public assistance agencies. And the litigation that used to be done at Project Vote and is now done at ACLU, Demos, and others was hugely impactful. Just an enormous amount of success. It flies somewhat under the radar because those cases usually settle out and don't result in judgments. But that has been an enormously impactful tool. We could talk more about the NVRA, but maybe of less interest because you are exempt from every last part of it in Wisconsin because you have election day registration and have had it since before the NVRA was enacted. I have just about a minute or two left, but I just wanted to pivot from federal court to state court before turning it over to Mel. It's hard to overstate how transformative a pro-voter, pro-democracy state Supreme Court can be. I'm probably not breaking any news saying that, but in states like North Carolina, Pennsylvania, Missouri, state courts have struck down their state's strict voter ID laws on state constitutional grounds. And when they do that, it cannot go to the US Supreme Court. It cannot go to the US Supreme Court. They have no ability to review a decision, a final decision that's decided on state constitutional grounds. Michigan now has a really good balance on its state Supreme Court. North Carolina used to, Pennsylvania still does. And the reason you don't see some of the worst voter suppression measures in Pennsylvania and North Carolina, the legislatures would have loved this, is because of the state Supreme Courts in those states. A successful case in New Hampshire that struck down a restriction on college students. It was a restriction, it was attacking their ability to claim residency in New Hampshire. That successful case was brought in state court. And last year, just lastly, the Pennsylvania Supreme Court extended the deadline for receipt of absentee ballots. There was a major fight about that as the Trump campaign tried to take that federal and bring it to the US Supreme Court, but it stuck. It stuck the landing, and that state Supreme Court decision held, and those ballots were counted. I think it was something like 10, 20,000 ballots, but hugely impactful. I'll stop there, and we can talk more in Q&A.
Thanks, John. There's just so much to cover, as you can all tell from John's presentation, and Wisconsin is the subject of so many of the themes that he identified from other states. So I want to talk specifically about what's going on in our state, but please keep in mind, this is a fight that's playing out across the country, and what happens in other states does sometimes impact our legal options here. Wisconsin is, however, for better or for worse, often leading the way on things related to attacks on democracy. And we hope, and one of the reasons that my colleagues and I started Law Forward is so that Wisconsin can lead the way in pushing back on some of these horrible attacks on voting rights. So where do these attacks come from? They really come from three different places. One is the legislature passing new laws that restrict voting access. We saw certainly plenty of those in this past session. They also come from litigation, from anti-democracy forces filing cases in court that seek to restrictively interpret or reinterpret our existing laws. And finally, they also come in the election administration context, which maybe gets less attention. But these are things that make it harder for the Wisconsin Elections Commission, local clerks, and poll workers, honestly, to do their jobs. That includes things like the call for the Wisconsin Elections Commission Administrator, Megan Wolf, to resign that Melanie mentioned, and also other things like Robin Voss's sham election investigation. There are aspects of this that are intimidating election officials. There are aspects that are just throwing sand in the gears and depleting resources so that these people can't focus on doing their jobs. And there are aspects that actually change the rules for how our elections function in Wisconsin. There are legal aspects and legal responses in all three of these spaces. So while a lot of what I'm going to focus on is the litigation where people have already filed challenges to reinterpret our laws, I want to be clear that lawyers, legal strategies, and of course our clients like the league have a really important role to play in all three spaces in repelling these threats. So as all of you probably know very well, Wisconsin used to be very progressive in leading the way in expanding access to the ballot. We were one of the first states to have no excuse absentee voting. And then things have really shifted, especially in the last 10 years. We now have one of the strictest voter ID laws in the nation, and that's been challenged in court, but we keep seeing these attacks come back and back. One of the biggest themes that we've seen lately is attacks on absentee voting, both in legislation and in the courts. That, of course, is really driven by the fact that more people have been voting absentee than ever with the pandemic and just a general move to that way of voting. So that'll be a major theme of some of the litigation that I touch on today. I don't want to spend too much time talking about bills that have been proposed in the legislature, because while it's very likely that they'll get litigated should they pass, I think right now our governor has clearly committed to vetoing anything that comes out of the legislature that makes it harder to vote. But if you're interested in the sort of bills that we've seen this past session and the ones that might come back in the coming session, because these proposals never really go away, I'm just going to drop a link in the chat to a place where you can see Law Forward's full analysis of the bills that were proposed in this past session. You'll see that many are restrictions on absentee voting that, if they do pass in a future legislative session, we can expect to see challenged in court. So some of the litigation that we saw in the 2020 cycle on absentee voting really related to how voters can cast their ballots and how they can deliver absentee ballots. So in Wisconsin, we saw challenges related to indefinitely confined voters and who can qualify for that status. Indefinitely confined voters vote absentee, but they actually have a special status under Wisconsin law that recognizes the challenges that they face in their life that may make it impossible for them to leave their home on election day, go to the polls, and cast a ballot there. We saw a case called Jefferson versus Dane County, which was a fight over who can be an indefinitely confined voter and who can vote using that method. This was honestly a victory. What the Supreme Court of Wisconsin held here is that the voter determines if they meet the definition to qualify for indefinitely confined voting. Now, they could have read the statute in a more expansive way that my colleagues pushed for, but really this was a win in protecting the ability to vote via indefinitely confined status. We've seen multiple pieces of legislation proposed since then to try to change that status, but this is a place that I think we can point to as a victory. An unresolved issue that I think we'll see future litigation about is what you probably all have heard of as Democracy in the Park. This was an event that Madison, Wisconsin held to collect absentee ballots. Now, keep in mind, these are ballots that have been mailed to voters' homes. They have filled them out. They have sealed them. They've signed them. Their witnesses signed them. They're returning them in sealed envelopes to election workers. And Madison deployed several election workers to parks so that they could safely collect ballots during the pandemic. It was outside. There was plenty of space. It was accessible. It was a much safer environment than many clerks' offices around the state. So here, litigation kind of stalled. The Wisconsin legislative leadership sent a letter to the city of Madison saying, this violates the law. You absolutely cannot hold these events. Voters have to come to a clerk's office to return these ballots. And some of my colleagues at Law Forward filed an action in Dane County court to say, no, we absolutely need the courts to clearly tell Madison that they can hold this event. People have already started voting this way. Their votes need to be protected. And that case didn't end up getting resolved. The judge there decided that until there was actually a move to exclude these ballots, that the court had no role in weighing in. Now, of course, we then later saw challenges to I think it was about 20,000 people who voted that way, those ballots, in some of the post-election litigation. But by that point, the judges looking at those cases said people have already voted this way. They've relied on this. We're not going to throw out these votes at this point. That does not mean that the legality of events like Democracy in the Park is clear. We think it's very clear based on reading the statutes, but this is something that courts may be asked to weigh in on again in the future. John briefly mentioned Zignego, which was the voter purge case. And this is a place where the League of Women Voters of Wisconsin was a client represented by my colleague, Doug Poland, and John at the Fair Elections Center. This dealt with who could be on the voter registration lists. Now, Wisconsin has its own system for keeping voter registration lists up to date. They mail postcards every 4 years and to people who haven't voted to verify that they're still at that address. But Wisconsin is also a member of a coalition and a group called ERIC, which is an interstate nonprofit that collects information about voters that suggests that they might have moved and that clerks may need to update their registration status. This was another case that I think we can point to as a relative victory. Here, the Court of Appeals held that under the statute at issue, municipal clerks and not the Wisconsin Elections Commission are charged with maintaining the voter rolls with respect to movers, and that the Wisconsin Elections Commission did not need to purge all of these voters from the list who had received these ERIC postcards instead of Wisconsin's own system. Now, one theme that I want to talk about a little bit more in depth here is the challenges over drop boxes and absentee voting, where voters deliver those ballots via drop boxes. This was something that we saw lots of challenges to during the election litigation. We saw another challenge after the elections were over, but ahead of the April elections, where anti-democracy conservative groups asked the Wisconsin Supreme Court to weigh in. They declined to, but those voters or those lawyers basically turned around and filed the same case in a circuit court. This case is called Tigen versus the Wisconsin Elections Commission, and it's a really important case to watch. This is ongoing. The League of Voters of Wisconsin is a client represented by Law Forward here. We moved to intervene to become a part of this case because it was conservative voters versus the Wisconsin Elections Commission. And we knew that the Wisconsin Elections Commission, for all the great work they do, is not charged with protecting access to the polls for all Wisconsin voters. They're charged with administering elections, and we wanted to make sure that voters had a voice in that courtroom advocating for the safe, convenient, and honestly non-controversial absentee voting method that is drop boxes. That case is ongoing. It's in Waukesha County, but I can tell you it will have impacts across the state, and it deals with the interpretation of a law that not only impacts drop box voting, but things like a husband or wife returning a spouse's ballot to the clerk along with their own. And again, we're talking about the voter filling out their ballot, putting it in that envelope, sealing it, but instead of dropping it in the mail, because we all know how bad the US Postal Service delays have been, someone else in your family returning that ballot to the clerk's office along with their own. So this law would not just impact drop boxes if it's reinterpreted, it could really make it absentee voting difficult across the board. I'm really proud of the work of our legal team in securing intervention for the league and our other clients in this case, because we were in front of a judge who very recently had ruled that similar groups could not intervene in a challenge to a DNR rule interpretation. So this is a place where I think really having a group of dedicated lawyers who are focused on this full time made a difference, and we were able to intervene in that case. I know that we're short on time, but I really want to just touch very briefly on this last piece in election administration, because I want you to all keep an eye on the sham election investigations that are going on in our state. Robin Voss, the representative and speaker in the assembly, has hired former Supreme Court Justice Michael Gableman to lead this investigation that is unnecessary, a huge waste of time, and honestly just a vehicle for intimidation of our election officials. Mr. Gableman has issued subpoenas that we will now be fighting about in court to 5 cities, as well as the Wisconsin Elections Commission. And this is something that I think you'll continue to see playing out over the next few months, honestly, in our state, and just shows how dedicated folks are to attacking the results of the 2020 elections and the really dedicated people around the state who administer our elections. So with that, I think we should open it up to questions, and thank you so much for joining us today.
Thank you very much, Mel and John. And I was remiss in not telling you a little bit more about Mel before she spoke, and to say that she has certainly been our feet on the ground here in Wisconsin as part of the Law Forward group. And she's a graduate of the university. And before she joined the Law Forward group, she was with Planned Parenthood and has been a strong defender of reproductive rights. So we're very glad that, Mel, you were able to be with us too. We have a question, and of course saying how much they admire the work that you two are doing, and asking how you actually decide to bring a case, particularly since the Supreme Court of the United States seems to be anti-voter and anti-voting rights. And then also, there's not been much more of a trend to protecting them in the state Supreme Court. So how is it you decide whether to bring a case? Because sometimes if you brought a case and you bring a case, the decisions may make the matter worse rather than better.
I'll take the first swing at that, and John, maybe you can weigh in as well. Considering the courts that we're going to be in front of and our chances of success there is an absolutely crucial part of this. There are many laws in the state and restrictions and bad interpretations that deserve to be challenged. We do need to be conscious of when is the right time to bring those challenges. And once we decide to bring those cases, we also need to make sure that we are making the strongest arguments to appeal to the folks on the court. Particularly with our state Supreme Court, we know that there are a majority of justices on that court that have expressed hostility to voting rights. So when we do decide to bring a challenge, we need to make sure that we are speaking to the kinds of legal interpretation that will resonate with them. And honestly, what that means is it's a lot more work to bring this kind of litigation, and it involves a lot more legal research and just a bigger team. So we're really grateful to be able to rely on lawyers around the country that we work with to help us think through these issues in the most effective way.
John, did you want to comment on that? If not, let's go to the next question. How can we protest the use of taxpayer money to fund this investigation of the last election? Is there a strategy for doing that?
Yes, unfortunately, I don't think it is a legal strategy in the courts. I think that the way to protest this use of taxpayer dollars, and it's almost 700,000 taxpayer dollars just so far, is really by holding the elected leaders making these decisions accountable. Call your legislators, call Speaker Voss, and tell them that this is not how you want your taxpayer dollars spent. In the meantime, the exact contours of the investigation and the ways that it is making it impossible for local cities and the Elections Commission to do their job, those contours we can litigate. However, the legislature enjoys really broad discretion about how they spend our public funds. And in the current state in Wisconsin, speaking to those legislators directly is the most effective way to change how those dollars are spent.
The next question is, why do you think Republicans propose laws that make voting more difficult for elderly and rural voters, some of whom are their supporters?
This has been a real question in Wisconsin this year. We know that counties that went for President Donald Trump relied on absentee voting just as much, if not more, as places like Madison and Milwaukee that are considered blue cities. And I think here the pressure really is just to restrict the electorate as much as possible. And while they rule out some of their own voters, in general, they have to think that this is a winning strategy for them.
Thank you very much. And I think our time is about up for the breakout room. And thanks so much, Mel, and thanks so much, John, because I think we want to stay very alert and aware of what's going on and not to think that the fight is over, because it may be just beginning, because there's this attack from all sorts of views. So in any event, thanks again. And we appreciate you being